Yes, sir. Absolutely. Absolutely. Sir, just we'll wait for a couple
No
of more
problem.
minutes and then we will begin.
No problem. No problem.
Absolutely. Okay. Uh, Let us begin. First
Yep.
of all, good evening, everyone. I would like to begin by extending my gratitude to Mr. Malhotra, who has, in spite of a lot of difficulties that he has faced over the last few days, it's a testament to his professionalism that he has agreed to take up this session even today, in spite of all the difficulties that he has faced. Thank you, sir, for this lecture. Uh, Before I begin, before I invite Mr. Malhotra to take over this session, I would like to give a brief introduction about Mr. Malhotra. He has had a very long and very happy association with our institution, with Symbiosis Law School. And to start off, Mr. Malhotra is a practicing advocate. He has attained his Bachelor's of Science and Bachelor's of Laws from the University of Punjab. Thereafter, he has obtained an LLM degree from the University College of London in 1985. He studied comparative family law at the London School of Economics and Law and Society at the School of Oriental and African Studies, SOAS. He is well conversant and independently conducting civil service matters, company matters, matrimonial disputes, and allied litigation at various high courts and supreme courts across India. And he has also worked as a lecturer. He has taught at Punjab University. He has been appointed as an honorary professor at Nual's Kochi recently. Uh, uh, Besides his presence as a resource person at various national law schools and at Symbiosis on various occasions that we have had in the past. Besides this, he has also rendered substantial assistance as an amicus curiae with regards to judgments that relate to inter-country parental child removal. He is also the author of a number of books, the most recent of which is Global Indians and the Law, published in 2020. He also has a book on the topic that we are talking about over here today, Intercountry Parental Child Removal and Law, LexisNexis 2016. He is also a fellow of the International Academy of Family Law, where he is an Indian representative for the same. Besides this, he has also lectured at the National Judicial Academy Bhopal on multiple programs, and also at the Chandigarh Judicial Academy. So it's a profile that speaks for itself. So without further ado, I would like to invite Mr. Malhotra to kindly take over this session and engage the students for this session.
Good evening, Professor Mukherjee. Thank you very much. Good evening to all students present. I am going to talk to you on a subject which is professionally a very engaging and a very enigmatic area of litigation, which is coming up in a big way in the practical field, because the challenges in this area of law are so immense and enormous that for a lawyer to get friendly, compatible, and adaptable to the law in child custody disputes is an uphill battle. I think before we begin, it may be best to first give you an idea as to what are the laws involved in child custody disputes. Now, just to fill you in, uh, as you know, the majority community in India consists of people of Hindu religion, and likewise are other communities, and we do not have a uniform civil code or a uniform family law. We have codified laws of all religious communities, and the primary law for the Hindus is the Hindu Marriage Act, the Hindu Adoption and Maintenance Act, the Hindu Minority and Guardianship Act, and the other laws for the Hindus. Likewise, Parsis, Jews, Christians, Muslim have their own laws. Now, let us go by what the law for the majority says. The law for the majority is the Hindu Minority and Guardianship Act. Now, Section 4B of the Hindu Minority and Guardianship Act defines a guardian, and it includes a natural guardian. And Section 6 of the Hindu Minority and Guardianship Act says that the natural guardian of a minor child shall be him the father, and after him the mother. Though in Gita Hariharan's case, Supreme Court says they are both equal. And the provision of Section 6 further says that the custody of a child less than 5 years of age shall ordinarily be with the mother. So there is a maternal preference under the tender years rule, whereby a child less than 5 years of age, the custody goes to the mother. But recently, in a decision of the Supreme Court in Lahari Sakhamuri, interpreting the best interest of the child, the Supreme Court has said that the maternal preference cannot be a absolute right. It has to yield to the welfare of the child. So this has been diluted to this extent. Then Section 13 of the Hindu Minority and Guardianship Act says that the welfare of the child shall be the paramount consideration. Now, the Hindu Minority and Guardianship Act, which was made in 1956, does not contain any procedure for a mother or a father to go to court to claim exclusive custody or exclusive guardianship rights. And Section 2 of the Hindu Minority and Guardianship Act says that it is supplemental to the Guardian and Wards Act. It is in addition to the Guardian and Wards Act and is not in derogation of the Guardian and Wards Act. So now we shift to the Guardian and Wards Act. Now the Guardian and Wards Act of 1890, it's not 1980, it's 1890. It's a 135-year-old law. It is a colonial legislation. It has outlived its utility. Report number 257 of the Law Commission on reforms in guardianship and custody laws, where joint custody, shared parenting has been recommended, has recommended that this law should be amended, but it stands as it is. Now, the Guardian and Wards Act 1890 In section 2, in section 4, defines a guardian as a person who's having the care of the person of a minor or of his property or both of his person and a property. Now, the Guardian and Wards Act in its preamble says that it is an act to consolidate the law relating to guardian and wards. Obviously, it meant to be at a time when we were a colony and the Britishers actually needed law for themselves, so they brought in this law. It is a secular law, it applies to all communities, and it is not confined to Hindus. So, this is the provision in section 4 regarding a guardian. Then section 7 talks of the power of the court to appoint a guardian. Section 12 talks of the interim/temporary custody orders. Section 17 talks of the matters to be considered in appointing a guardian, and the sole consideration, it is said, is the welfare of the minor. Then section 19 says when the natural guardian is to be deprived of a guardianship, then the father and the mother have to be declared unfit if a guardian, that is any person other than a natural guardian, is displacing the father or the mother. Then section 25 talks of return of a ward to the guardian. So if a child is removed from the custody of a guardian, then under section 25, the guardian can go to the court and seek the return of the ward. So effectively what happens? Whenever there is a custody dispute and one parent claims exclusive custody over the other parent, he or she files a petition under the Guardian and Wards Act claiming exclusive custody, claiming sole custody, and then the court deliberates on how this is to be resolved. So this is the backdrop of what has been in the statutory law for old times to come. Now, there is another development. We in India have signed the United Nations Convention on the Rights of the Child. Now, after India signed this convention in 1993, India was perforce obliged to adapt, incorporate, and have all the provisions concerning the welfare of the child in the Indian statutory laws. So that is the way, procedure, and method how the provisions of an international convention signed by India, acceded to by India, are made part of statutory law. So the UNCRC effectively talks of the right of the child to a nationality, right of the child to a home, right of a child to be loved and cared by both parents, and the child to a passport, to citizenship, and not to be separated from both his parents. Now, all the ingredients of the welfare and the best interest of the child have been incorporated in an Indian statute, which is again secular in nature. Now, there is a law regarding the children, and the law is Juvenile Justice, Care and Protection of Children Act 2015. This is commonly known as the JJ Act. It first came in 1986. It was amended 2-3 times thereafter. But ultimately, the most exhaustive amendments took place in 2015. And in the preamble of this act, it is said that after India has signed the United Nations, India has ratified the UNCRC on 11th of December 1992. So all state parties are required to have appropriate measures. So therefore, India is having a set standards to be adhered to in securing the best interest of the child. And while doing so, in section 2, subsection 9, the best interest of the child was defined. It says best interest of the child means the basis for any decision taken regarding the child to ensure fulfillment of his basic rights and needs, identity, social well-being, and physical, emotional, and intellectual development. So this definition of the best interest of the child has got incorporated in the Indian law. So whenever a court is now asked to determine the welfare of the child, Section 29 of the JJ Act is invoked and applied. Now, it is said that the JJ Act will not apply to children in normal circumstances. It only applies to children in conflict with law, children in need of care and protection, and often abandoned and surrendered children. But the argument is that a child in need in care and protection is also a child who is in the custody of one parent and whose custody is sought to be deprived by one parent to the detriment of the other. So, therefore, this child needs the protection of the court. So, we now have this definition coming in, and courts have now started somewhere in 2017-18 in child removal matters, particularly inter-country, interparental child removal matters. The courts have started looking at the definition of the best interest of the child, and there seems to be now no preference of the mother or the father exclusively on the basis of gender. What is seen is who can look after the child better, where did the child have his home, residence, and place of closest contact. That jurisdiction, that court will decide the issue regarding the custody matter. Now, we move a little further to the law on how do you recover the custody of a child when one parent, to the detriment of the other, takes away a child and refuses to share the child with the other parent. Now, the normal conventional way is to go to the guardian judge under the Family Courts Act and seek the return of the child. So you file a petition under the Guardian and Wards Act. Now, Section 9 of the Guardian and Wards Act says that the petition for the custody of a child shall ordinarily be filed in the court where the minor ordinarily resides. Now, minor ordinarily resides has been interpreted by different courts to mean where the child is habitually and permanently resident and not where the child is present on the date of the filing of the petition. So this is a very decisive factor on the jurisdiction of the court to determine as to where the petition should be filed. Now, the sad part of the story is that this concept only leads to a custody battle between two parents, and the natural guardian, despite being a natural guardian, is forced to go to the court to seek singular custody, and the opposing parent is also in a counterclaim seeking to say that he's a better parent. So this rigmarole of law is a very big challenge for lawyers to handle in this perspective. Now, till the Family Courts Act 1984 came into play, the powers of the guardian judge were with a civil judge in the district courts who would decide the guardianship disputes. But when the Family Courts Act 1984 came and family courts were established under Section 9, under Section 7, the jurisdiction of the family court extends to all proceedings for the custody of a child. So in Section 7, you have a number of issues regarding matrimonial matters. So anything to do with marriage, divorce, validity of a marriage, then property of the parties, then proceeding regarding injunctions, then suit or proceeding regarding legitimacy, then suit or proceeding for maintenance, then a suit or proceeding in relation to the guardianship of the person or of the custody or access to the minor. So once there is a family court in place, then under Section 7 of the Family Courts Act, the family court's jurisdiction will be invoked to decide a dispute regarding guardianship and custody. Now, there is another complexity in this perspective for law and lawyers in child custody disputes when the issue is not domestic, but the issue is international. So you have, let us say, a couple married in India of Hindu religion who have relocated to America, Canada, England, Australia, or Germany, who may have even acquired the nationality of that country, who may have even become citizens of that country, but are having child custody disputes at issue. Now, here I pause to add one very important perspective which really finds place, that we are Hindus by religion. Now, all Hindu laws have extraterritorial application, which means regardless of wherever you go, England, Canada, Germany, America, Africa, wherever, regardless of whatever nationality you may acquire, citizenship you may acquire, domicile you may acquire, you will always be a Hindu by religion unless you consciously change your religion. So therefore, if you have a child and one parent walks into with the child in India, then the determination of the child will always be done on principles regarding concerning Hindu law, because that is the personal law. It is your law of marriage and divorce. It is your law of custody, which will apply to you, and it will come in through the Family Courts Act and the Guardian and Wards Act. But regardless of the fact of religion, welfare of the child will be the paramount consideration. So now let us examine a situation getting complex for a lawyer. There is a dispute where parties have got married in India. Let us suppose the child of the parties has been born in a foreign jurisdiction and is a foreign national, has lived in that country. There is a dispute. Mother or father have walked out with the child and come to India. Now, what is the status of such a situation? Is it a wrong? Is it an offense? Has it got any consequences? The answer is no. And the simple reason for the answer being no is that interparental child removal is not recognized, is not labeled, is not labeled, or is not in any terms under any statute called a statutory wrong or an offense. So if you are a natural parent and you have removed your child, you are a natural guardian. You have excluded the other parent. Law says no wrong done. It may amount to kidnapping under 361, 362, 363 if any other person other than a parent removes a child. But parental removal is not kidnapping under the IPC. In civil law, there is no wrong. Where is the wrong identified? Where is interparental child removal recognized as an offense? Now, in terms of international law, there is a Hague Convention on Civil Aspects of International Child Abduction, 1980, signed by 105 countries, in which wrongful removal or retention of a child has been defined. And it means that when a child is removed from the custody of one parent and taken to a jurisdiction depriving the other parent of his rights by virtue of his parental rights or of an order of a court, it amounts to wrongful removal or retention. Now, India has not signed the convention, but 105 countries which have signed this convention recognizes this as wrong. And how does this convention work? The convention works by a system of every country signing the convention creating, first of all, an internal law to define that it will be a wrong or an offense. Then the country will create a body known as a central authority who will entertain applications for child removal and will interact with the central authority of another country for applications regarding child removal. And between the two central authorities, applications will be exchanged and they will decide whether the child is being wrongfully removed or not. Now, we have not gone into this. There is a lot of debate on whether India should sign the convention or not. I assisted the Punjab and Haryana High Court as an amicus, that is a friend of the court, for 12 years in a matter where a child was taken to England by an aunt, not returned. I gave a report, and the matter was ultimately referred to the Law Commission. Law Commission gave a report. Then the Government of India constituted a committee to look into the issue. There were 6 honorable judges, 6 government officers. I was the only lawyer on the committee. We interviewed a lot of people all over the world online, and we have a 2-volume report of the. It is called the Bindal Committee report. It's available online, and we have recommended that India should recognize interparental child removal as wrong, and India should take steps to create a central authority and come in force and join this international movement. But nothing has been done so far. So status quo prevails, stalemate prevails. Now, the dead end is that most judges in foreign jurisdictions do not allow children to come to India for the simple reason that India will not return a child and Indian courts will determine the welfare of the child. So, what happens? What is the remedy a lawyer has to face? What is the remedy a lawyer adopts? And what is the remedy I will adopt if I have a parent with a foreign court order wanting his child to be returned back to the country from where the child was born, where the child has lived, America, England, whatever? I will invoke the writ of habeas corpus under Article 226 of the Constitution if I have to go to the High Court, or I will invoke the jurisdiction under Article 32 if I have to go to the Supreme Court of India. So you all know that the Constitution of India vests extraordinary jurisdiction under 32, Article 32 with the Supreme Court, and under Article 226 with the High Court. There are 6 different types of writs. Habeas corpus is one of them. Habeas corpus is a writ seeking to recover the illegal custody of a person from confinement. But then, Gohar Begum, 1960, Neil Ratan Kundu, 2011, then Surinder Kaur, then Lahari Sakhamuri, and subsequent decisions say that when the habeas corpus jurisdiction of a court is invoked for recovering child custody, it is not addressed to the illegality of the detention. It is addressed to the welfare of the child. So the High Court or the Supreme Court, in exercise of such jurisdiction, when entertaining a writ of habeas corpus, looks to the welfare of the child and addresses questions regarding the welfare of the child when the writ is invoked. So for a parent to say, I am not holding my child in confinement or illegal custody, in an argument which will not work, because the court can say, I, in my jurisdiction as parents betray, I, in my jurisdiction as the guardian of the child, will take a call on the welfare of the child. Now, Ruchi Maju's decision by the Supreme Court in 2011 says that when a guardian judge has an application or a petition of guardianship or custody, then the guardian judge can only entertain the petition if the child ordinarily resides in his jurisdiction. So therefore, if the child does not reside in the jurisdiction of the court, the guardian judge has to decline the application and return it to be presented to the proper forum. So this is concerning the jurisdiction of the guardian judge. But the Supreme Court further says in Ruchi Maju that when the issue is regarding the custody of a child in a writ petition, The extraordinary jurisdiction of the court extends to the child as parents portray, and therefore there is no limitation on the power of the High Court to exercise its writ in such situation and such circumstances. Now, I am going to demonstrate to you a case which I argued very recently and which was decided on the 16th of November 2021 by the Punjab and Haryana High Court, which is a very interesting decision to explain your lecture today on law and lawyers, child custody disputes, the dilemma. Now, this is the first I'll give you the facts of the case. The facts are that there are a husband and wife belonging to North India of Hindu religion who marry, and they after marriage they live for about 10 long years in England, and they have two children. The daughter is born in India. The daughter is supposed, let us say, 11 years of age. The child born in England is about now 2.5 years of age. So in 2019, the parties consciously decided to return to India because they thought the children were very small and they needed to look after the children and develop the family, which was better to be done in England. Now, as far as the child born in England is concerned, they had taken an Indian passport for him. Now, let me explain the complexity on this issue here. Now, as far as the law of citizenship goes, India does not allow dual nationality, which means you cannot hold passports or nationality of two countries. Article 9 of the Constitution and Section 9 of the Citizenship Act says, once you become a citizen of any other country, you cease to be a citizen of India. So if a child is born to, say, Indian parents or British or American or Canadian parents, they have a choice. They can either adopt the citizenship of that country where the child is born, or under the Citizenship Act, they can go to the Indian High Commission or Indian Embassy in that country and register his birth and take an Indian passport. Now, in the case at hand, an Indian passport was taken for the child and the parties relocated back to India. They started living here. Now, the man's work required him to travel a lot. So he hired an accommodation, took an apartment on lease, got his child admitted, and he had to go to the US, but he got stuck in the pandemic. And when he came back, he found that his wife had gone to her parental home with the two children. So he went there. She refused to come back. He filed a petition for restitution of conjugal rights, but she reacted in an adverse way. Nothing worked out. So they were separated. Now, sometimes in May 2021, during a conversation in a call, the husband discovered, much to his shock, that the wife stated that I am in England with the two children. Now, she said that she had the rights of permanent residence, and to revive her rights of permanent residence in UK, she had gone to England within a certain time frame and she had taken the children with her. So this gentleman filed a petition online in the High Court of London for the inherent jurisdiction of the court for recovering the custody of the children from and seeking their return back to India. Now, whilst this petition was pending, the court in England, High Court at London, gave him access to the children every Monday, Wednesday, Friday at 6 p.m. GMT, which meant 10:30 in Indian time. Now, whenever this father used to talk to his children, he found that his son was always asleep at 6 p.m. and invariably the backdrop was muted and there was no sound. So he was very suspicious. So he, with his mother, sister, and brother, went to his in-laws' place in India where they were staying, and he, much lo and behold, to his shock and surprise, he found his son playing in the street. There was an altercation. He was beaten up. He was hospitalized. We moved a habeas corpus in the Punjab and Haryana High Court and said that the custody of the child needs to be given to the father. Now the question arose, which court has jurisdiction? The mother said the father is invoking the jurisdiction of the courts in England and in India simultaneously. This can't be. So my argument before the court was that because the child is in the jurisdiction of the Punjab and Haryana High Court, therefore the petition so far as the jurisdiction or the return of the child from England has become infructuous. And only this court, within whose jurisdiction the child is present now, as of now, parents portray requires the child to be returned to the natural father. Then the next question was, what is the preferential right of the grandparents over the natural rights of the father? And the short answer to this question was that the father is the natural guardian under Section 6, along with the mother. And once it is proved that the mother is in England, then the grandparents have no right. So what was happening was that whenever the father would call at 6 p.m. Monday, Wednesday, Friday, the mother would produce the child as if he was sitting in London, but the child was actually in India. So I said to the court that the court in Punjab and Haryana has the jurisdiction to return the child back to the father because the grandparents have no preferential right under Section 6, where father and mother are natural guardians. If the maternal grandparents claim a preferential right, they have to go to the guardian judge. They have to invoke the jurisdiction of the Guardian and Wards Act, and they have to claim preferential rights. They have to get the father declared unfit, and they have to take custody and guardianship rights. Now, the argument of the mother was that I want the child to be brought to England because the child is a British citizen. Now, the question was that the child was born in Britain. He was entitled to British citizenship. He was also entitled to Indian citizenship. The parents had consciously opted to take the Indian citizenship, not the British citizenship. So therefore, the child was not a British citizen because the child was holding an Indian passport and therefore he could not hold a British passport. Then the next question was, why should the child travel to England? The judge said, I am not permitting a 2.5-year-old child to travel to England in these circumstances because he's too small. And what is the mother going there for? No job, no place to stay. Here there is extended family. Environment is much better. Scare of COVID is still there. Now, the High Court in London issued an emergency passport to be issued by the British High Commission in Delhi for the child to be brought here. So the court again was told that the matter is pending in the Punjab and Haryana High Court, and therefore this emergency travel document should not be issued. Well, the High Court in London held back and said we don't need the child. We will only look at the welfare of the girl child. Now, the girl child by now had also gone into serious alienation. Now, parental alienation syndrome is another fallout of such broken families, where a child who is in the custody of one parent starts leaning on that parent and starts disbelieving the other parent simply for the reason that the child feels insecure. So I told the judge that the child is severely polarized and therefore anything said by the child ought not to be believed. And the welfare of the small boy requires him to stay back in India and to be looked after by his father. But then the mother said the father will again go away because of his work. So ultimately the matter has been decided. The English High Court has ruled that the mother and the daughter will stay in England. The boy should also be brought to England. But because the Indian High Court is seized of the matter, therefore it should decide what is to be done, and we will take a call on it in February 2022. The Punjab and Haryana High Court has decided that the child should be returned to the father by the maternal grandparents. The mother will have access by video conferencing every day. Maternal grandparents will have access thrice a day by video conferencing. And the father will not travel abroad for 6 months and will bond with the child because he has not had a relationship along with the child. So this latest case is a mix of all the issues, and I have circulated the judgment. So for you to understand this topic, this is the best judgment. Now, going back into uh, the law, now because we have no statute to define child custody, to define joint parenting, to define shared custody, so we go, the judge in the family court or the guardian judge in the civil court goes by conventional principles of singular custody. So what do we have? We have crisscross opinions starting from 1984, Surinder Kaur's case, where Justice Y.V. Chandrachud said that the jurisdiction which has closest contact should decide the welfare of the child and children should be returned. This went on till came Dhanvanti Joshi and Nirja Saraf, where Supreme Court said no, we will not stamp foreign court orders, we will decide welfare. Then there was the Supreme Court decision by Justice Loda in a petition under Article 32, where Supreme Court said no, child should be returned back because the child is being has belongs to a foreign country, that is his natural habitat, that is the country which has closest contact, and that is the country which has the best place to determine his welfare. So this decision was rendered, and then slowly we came into the law being crystallized in Surya Vadanan in 2015, where Justice Rukur said, first strike, whichever court takes on jurisdiction for it will decide. Second, committee of courts. One court passes an order, other foreign court should respect the order. Third, jurisdiction of closest contact, whichever has closest contact will decide. Now, this decision in Surya Vadanan was watered down in Nityanand Raghavan by a bench of 3 judges, whereby they said there is no theory of first strike. It's a bad principle. There is no committee of courts in child custody disputes. Only principle upheld was jurisdiction of closest contact and welfare of the child. Foreign court order, one consideration. Now, this decision of the Supreme Court in Surya Vadanan has been watered down in Nityanand Raghavan, and subsequently this is now being followed in Lahari Sakhamuri, Tejaswini God, Yashita Sahu. All the subsequent decisions of the Supreme Court are being followed. But as I told you, Justice Loda's judgment under Article 32 in the famous case of V. Ravichandran still is good law that a writ petition is available. So as we can crystallize the law now is, the law is that a writ petition is maintainable for child custody issues, and you cannot say a writ will not lie because there is a statutory remedy under the Guardian and Wards Act. Second, that the welfare principle will be paramount in deciding custody. Foreign court order will be one consideration only. So a High Court or a Supreme Court in a writ jurisdiction can hold a summary inquiry or can hold a detailed inquiry. It can direct the return of the child, it can decline the return of the child, or it can direct that the matter go to the guardian judge of the family court for a decision on custody issues. Fourth, the jurisdiction of closest contact ought to ordinarily decide what is the custody issue. Now, I did another very interesting matter which lasted almost 3 years. Navtej Singh's case, it's reported everywhere. So this was a case where a lady came to attend the wedding of her brother. There was only one girl child. While she was here, she refused to go back. She gave birth to a boy, and she filed a petition in the Guardian and before the family court in Delhi. The court ultimately declined that it was in the welfare of the children to be retained by the mother. I filed a habeas corpus. Habeas corpus I succeeded. But the judge put me into another very interesting proposition, which I must share with you as a lawyer. The judge said, I am imposing conditions on you. You will not separate the children from the mother. You will look after the mother and the children by providing them $25,000 over a year. You will not take out criminal proceedings. You will let the court in England, in US decide ultimately. Now, once the Delhi High Court passed this order, the Delhi High Court said, now you go to the US court and asked the US court to make the Delhi High Court order a part of the Delhi High Court order. So this is called mirroring an order. So I got the Delhi High Court mirrored in the US court order, came back. The mother still refused to go back. Matter went to the Supreme Court. Ultimately, Supreme Court decided it. The mother has ultimately gone back to US this year only, after almost staying for 6 years in Delhi. So mirror orders is another way in which things are turning around for the better, uh, insofar that return of children is concerned. But it has also not found favor in Perry Consagra's case. Now, Perry Consagra's case is where a child born to a couple of Hindu religion, father is a Kenyan national, lives in Africa. The mother brought the child and refused to return the child. Father filed a petition under the Guardian Wards Act, succeeded, came to High Court, succeeded. Mother came and appealed to Supreme Court. Supreme Court dismissed her appeal, but asked the father to produce a mirror order from Kenyan courts. So the father produced a mirror order from the Kenyan courts, gave 1 crore rupees as monies to secure the mirror order, took the child to Kenya. Now, when the child had to be shared back to India with the mother, the father refused to return the child. So the Supreme Court reopened the case, held him to be in criminal contempt, and the Supreme Court has recalled the mirror order judgment, and the matter has been remanded to the family court. So these are the crises and crosses of the litigation. And as a lawyer, I find studying this concept, practicing this concept for almost 35 years now, over 35 years now, that you as a lawyer have to innovate thoughts. I remember doing a case in Goa, where there was an English mother living in Ireland. There was an American father, and the father had relocated to Goa after he had given up work. Mother was still a teacher in Ireland. They had got married under English law or Irish law, which did not permit divorce. So there was no proceedings. So they were sharing custody of the girl child 6 months apart. So on one occasion, the father refused to return the child to England. I filed a petition for habeas corpus in the High Court at Goa, saying the child needs to go back to England. She should be learning catechism. She should be learning ballet. She should be learning French, German. She's living here learning Konkani. She's totally unaccustomed to being with the father. Now, surprisingly, the High Court at Goa did not agree with me and said the matter will be decided by a family court. And ultimately, even the Supreme Court affirmed the decision. So this is again a crisscross of another situation where things went bad. Now, there was another case I did in Gujarat where there was a couple of the Bhora community. Now, in the Bhora community, you marry first cousins. So the two sisters had a son and daughter. So they were married, and they were in the US. When the mother came to Ahmedabad on an occasion, she refused to go back. I represented the father in Ahmedabad in the Gujarat High Court, and both the children were ordered to be returned. The mother handed over the children, and the children went back with the father. So this was another case in which the children got to go back. So this is the backdrop of how interesting this area is. It's something which is developing. It's a developing jurisprudence. It is a very challenging field, and you as a lawyer have to innovate, think out of the box, and carve out a solution on a case to case basis. And every time you have to apply your mind to see what you can do, because the law does not answer a conventional situation, and you have to put to a judge what to do. So whenever I am within in a court as an amicus, I was an amicus in a matter recently where a child had come for a surgical procedure to India. Mother refused to go back. The father wanted the child back. So I suggested to the court there should be joint parenting and there should be shared custody. In all countries in the West now, joint parenting and shared custody is becoming more of a rule, more of a procedure. That is to say that nobody talks of singular custody anymore. Everybody says it should be shared parenting, it should be joint custody. And talking of singular custody or sole custody is considered to be somewhat archaic. But we in India have not changed, and we are still stuck on the concept under the Guardian and Wards Act 1890. Now, some courts innovate. Now, under the Family Courts Act, the family court is free to innovate its own procedure. It is not bound by the rigors of evidence and procedure and can design its own procedure. So that gives a lot of flexibility to the court to take on in matters in deciding child custody. But the fact of the matter is that the number of matters before a court and the size of litigation in different matters is so huge that a judge cannot really have time to think out of the box. So, as a lawyer, you have a very important role in feeding to the court what you think is the best possible. So, if you want the court to have give you custody, go to the court and say, I have a shared parenting plan, I have a joint custody plan. Monday to Friday, mother, weekends, father. I will drop, I will pick. So, this is the best way you can have the child, best of the child, and the child will have the best of you. So, as a lawyer, you have to think differently. You have to put to the court a solution which the court can implement, but it is your innovation, it is your creation, it is your uh, way of looking at it. Now, I remember there was another very peculiar case where there were two girl children. I was an amicus in the case. Now, the mother had died in very mysterious circumstances, and at the funeral pyre, the children were taken by an informal agreement by the maternal grandmother, and they continued living with the nanny for a long period of time. Now, the father filed all kinds of petitions, but never actually succeeded. And as time grew, the girls grew. They refused to. They refused to meet the father, interact with him. So when on one occasion the matter was in the High Court judge transferred the guardianship proceedings to the High Court. So he told me to mediate and find out a way. So I tried to arrange a meetings with the nana nani, the mama, with the paternal grandparents and the father of the children. But the acrimony was so strong that the girls wouldn't go let hold of me, and they said we don't want to go to our father. So we started on a limited way of access and custody, but it really didn't work out, and status quo still prevails. So this is a backdrop of all what I have been doing and all what I have done in a perspective. So with this food, uh, let us have a discussion now. So whatever view, observation, question, perspective you have, you should open out, ask me questions, and let's have a discussion. So, sir, we are back to you. Can you open the floor for interactions?
Yeah. So I'll request everyone who wants to ask any question, please kindly raise your hand, and then we can go one by one.
I think, sir, you will have to open the floor. Once you start, then
I think first one to go will be, yeah, I have a student going first, and it will be
Archie
Archie.
Gar.
Archie, can you please go ahead?
Yes, good evening, sir.
Yeah, hi.
Sir, I had a question. Since
Yes.
you mentioned that we should put forward the innovative solutions for the custody of the child in case of international issue. So,
Yes.
what if there is an issue for the property or will related to that particular child? How to go ahead in that particular case?
You see, that will depend on in which country was the will made. Now, uh, the will be some substantial monetary benefit for the child, for his future, for his education, for his upbringing. Now, that may be a factor to determine the welfare, momentarily. But as courts say, monetary comforts, superior financial capacity of a parent, or issues of wealth will not prevail over a poorer parent who can look after the welfare of the child better. So, monetary considerations cannot prevail over the welfare. So, if there is a parent who doesn't have superior earning capacity, just because there is a will in favor of the child, or there is a will, there are assets in favor of the child in a jurisdiction other than where the child is, that will not be an overwhelming factor. It may be one of the considerations. So, superior earning capacity, better financial strength cannot be a overwhelming, overriding factor on the welfare of the child.
Got it, sir. Thank you, sir.
Okay, yes. Next.
Anyone else who wants to go?
I expect a debate, sir. There should be more interactions.
Yes, sir.
Yes.
So there's Samriddhi. Samriddhi, can you?
Sir, so basically my question was, can you hear me?
Yeah,
Uh,
yeah, loud and clear.
yeah,
On.
yes, sir. So, sir, my question was basically around parental custody in terms of LGBTQIA plus relationships, where either both the partners had adopted a child or one of the partners transitioned, etc.
Hmm.
So, I don't think India has still seen such a case being presented across its courts. So,
Hmm.
what do you think should be an approach in such a case? Because we're already seeing a spurt of growth in this area of family law
Hmm.
across the world. So, what
Hmm.
are some inspirations that we should take across, like take from other jurisdictions, or is there some new path? As you said, that this is one area where lawyers need to continuously innovate because every situation is novel.
Hmm.
So, what do you have? What is your opinion regarding the same?
Very good question. You see, your question can be married to children born out of surrogacy. So, let's not talk about people like Tushar Kapoor or uh, Karan Johar who are single parents. Let us talk of a case where there is a LGBTQ couple or a bisexual couple or a gay couple with a child born out of surrogacy or adoption. And let us consider a case of a child born out of surrogacy of a heterosexual couple. What do we do? Now, I did a case of a very influential, powerful family where a child was born out of a surrogacy between a normal husband and wife. So the man said, she's not the mother of the child. Child is born out of surrogacy. So that fell nowhere because she had contributed her ovum. So regardless of the fact that she had not gone into pregnancy made no difference. She was still the natural mother. Now, what you are posing is a same-sex couple. Now, our law, first of all, does not recognize same-sex marriages. So, if there is a custody dispute between a same-sex couple, I have not seen one coming to court. But the question, I think, let us say, in a hypothetical case would be, who is a better parent? Who is if let us say, if they are both males, who is a mothering father? Or if there are two women, who is a better parent? So I think if there was a case, somebody, let us say, who is a stay home parent, secure financially, compared to a parent outside, working, not available to look after the child, I think the custody would go in a same sex couple on the welfare of the child. Who is a better caring parent? who has got the more time, who has got the better resources, who has been looking after the child more, who has actually been caring for the child more, who is more attached to the child more. If the child is old enough to express wishes, is the welfare of the child determined? Can the welfare of the child be determined by interviewing the child, hearing the child, the voice of the child? But then the question may be, uh, can such a dispute be decided in the Guardian and Watch Act? I haven't seen one. Somebody can come up. We are already recognizing relationships in the nature of marriage under the Domestic Violence Act. Though we don't recognize unmarried cohabitation, we have demolished consensual behavior in the private by decriminalizing homosexuality. So there may be a case, yes, where we may look at deciding parenting in a gay couple. And I think the welfare will be the paramount consideration. Dehorse genders. Interesting question. Let us hope somebody files a case one day and things come up.
Thank you, sir. I just have another follow-up question
Yeah,
regarding the
sure,
same.
sure, sure.
Sir, as you reiterated that it should be a caring parent and mostly it will be guided based on the welfare of the child.
Yeah.
So basically, do you think the best interest of child is a good principle in this case? Because in a lot of incidents, especially in terms of LGBTQIA couples, even if we don't talk about same-sex couples or if we talk about one partner transitioning as a trans man or a trans woman, it
Mhm.
usually leads to a lot of transphobia, or it somewhat leads to diminishing their bodily autonomy just to determine whether they are a good parent or not. And the European Court of Human Rights has witnessed such cases where, I mean, recently there was a case where something of such nature happened where the bodily autonomy of the father, who is now a trans woman,
Mhm.
was somewhat violated in terms of determining the fact about whether he was a caring parent or not. So
Mhm.
do you think isn't in some way or the other the family law very skewed in terms of seeing LGBTQIA plus relationships even from the lenses of child custody?
Yes, it is. You see, face it as you may, the custody laws are archaic. We are actually still looking at a 135-year-old law. We are actually, you're very right, the word is skewed. We are, it's unfortunate that despite Justice AP Shah's report 257 of the Law Commission of India, way back in 2015, we still haven't gone into a change. And we really need to rework the things. We really need to start looking at uh, things in a different way. Now, transgenders have been recognized as a third right. We are now seeing transgenders being seen as persons. Uh, right to unwed couples having custody is being recognized. A child taken away in adoption recently in Kerala was returned to the natural parents. We have Puttu Swami, a 9-judge constitution bench judgment talking of the right of privacy. Now, in this backdrop, there is a conflict of thought. See, on the one hand, you have a right of privacy, let us say, of a transgender. But then, on the other hand, you have a conflict of a child's rights vis-a-vis transgender's rights. The question, uh, in a larger perspective, is that if there is, let us say, a normal parent and there is a transgender parent who are in a relationship, and there is a child by adoption or by surrogacy or whatever, is it in the welfare and the interest of a child to be with a transgender parent or in to be with a normal parent? I think is a question which will be determined on the welfare principle, seeing what is best suited to the child. How is the child going to be affected by it? And let us understand that when you decide about custody, you have to have a clear perception that you are not talking of the rights of the parent. Don't mix up the rights of the parent with the rights of the child. Whether you're a transgender or whether you're a normal sex person is of no concern when it comes to the rights of the child. What is better suited to the child? We cannot look at the custody issues of a child vis-a-vis the rights of a transgender father or a mother. What is the fate of the child with the transgender parent? Is the child going to be happy in society? Will the child face a dilemma with a transgender parent? Is the transgender parent in a position to look after the child like a normal parent? Now, these are questions which have to be seen from the lens of the welfare of the child. Now, the welfare of the child is something we can't get out of because India is a signatory to the United Nations Convention on the Rights of the Child. The best interest of the child has been defined. Now, because we don't have any other definition, because we have no other way in which we can expound the concept, there is no fallback except on the best interest of the child. Now, in my view, the judge has to see with his judicial lens and microscope, his training, his learning, and his experience. Here is a normal parent, here is a transgender parent. Is the child grown up enough to understand what is a transgender parent? Or is the child going to grow up with mixed feelings? Is the child going to be confused about his parent's identity? Is it good for his mental growth? I think these are very relevant considerations which will be material. And it depends on the kind of society the parents are in. Is it a modern city? Is it urban setup? Is it a semi-rural or a semi-urban society? So I think these are all very big decisions which may come in. There has been no real contest in some places, but this will come up someday in some situation. I remember a very interesting matter in which a couple had a child and a third person came up and said, "This child is mine. I have impregnated the woman with the consent of the husband and the wife because the father, the natural father, the husband was not capable of procreating, and the child should be given to me." Surprisingly, the family court dismissed the petition saying, "You are nobody." So we have gone in High Court saying, "I am the natural biological father, so I have rights." So this is another dimension of how things will emerge. So these are all gray areas, and this is where law and lawyering will come about. How can you think? How can you innovate? How can you take the argument out of the box? How can you make the judge carve, split, stitch, and sew? See, a lawyer is like a tailor. He has to find a cloth, he has to measure the size, then he has to cut, and then he has to tailor make according to requirements of the case and put it before the judge. So this is what it is all about. Very interesting question, thought provoking.
Thank you so much, sir. Thank you.
Yes, next question, please.
Yeah. Who
Any
comes next?
provoke?
Sir, in the meantime, before the students can ask the question, I have one from my end.
Sure.
Sir, this is with regard to your statement about the shared custody as a thing, and now if we look at the context of our country, most barring the elite or the middle class section of the society, for the greater underbelly of our country, it's normally the mother who is taking care of the child.
Yes.
So and again we have our obligations with regards to following the best welfare of the child principle in determining custody. So do you think this shared custody principle should be more of a permissive principle, or should we try to make that as some kind of a norm? Because if it's a norm, then there may be a conflict that may arise in this regard.
You're very right. This is an urban concept. This is a, so to say, let us say, this is a somewhat elite concept. This is a concept where both parents are earning, both are economically independent. Now, let us examine the situation from the perspective of the majority of India, where the woman is dependent on the man, where there is no question of the woman even surviving without the pay packet of the husband. And she has no choice but to be left at the mercy of what the man says and does. Now, in this, the woman has no choice but to bow down to anything what the man says. So, for her to fight on custody issues may be a very, very difficult task. And the man will say, all right, if you don't want to give me any custody, you don't want to give me any visitation, I'll not give you maintenance. So the poor woman has no choice. So there again, a shared custody may evolve by reason of economic necessity. But you are right. This now we must also understand that with the outburst in development of economy, with the creation of jobs in the IT sector, the availability of people with basic schooling being employed, being economically independent as some kind of computer trained persons, a lot of economic independence is taking place. And I see a lot of eruption of matrimonial disputes, irrespective of how strong economically independent a girl or a boy may be. Now, in this concept, in this scenario, if in an urban setup we start introducing shared custody without making it a norm, but making it a requirement on tailor-made basis, let it not be a norm. So the concept now, the Family Courts Act leaves it free to the court to devise any way of settling the matter without being bound down by the formal rules of evidence or procedure. So it should not be a norm, it should be an option. Uh, you should also realize that singular custody is wrong and harmful for the child, regardless of whether it is an economically deprived couple or it is a well-placed couple. A child growing up with one parent does not receive the love and affection of the father and the mother. So he will always have something missing in his life. Money can be replaced with love, care, and affection. So the concept of shared parenting, joint custody, is also based on the welfare of the child. A child with a father and a mother caring, maybe by sharing, may have a child be becoming a happy child, having a normal bonding with the father and the mother. As you see in the West, the father walking in to take away his son or daughter, who is now living with the mother who has remarried, and there he knocks at the door and the new husband opens and they cordially greet each other. Now, these are things you see in the movies. But, this is something which may happen in India also after 25 years. So looking down the line, I think looking at the child as an individual and considering that the child needs both father and the mother, it is better that we start looking at this concept in a implementable way, but making it an option, not the norm. I'm glad you've given that phrase, not the norm, not the rule, but an exception or an option. I think that's the best I could put it at.
Yes, sir, completely. I agree with you on that regard.
It's an
Okay,
interesting concept.
students, any other one? Any? Yeah. Yes, sir, please.
See, this is going to develop. This is something we have to we have to create. See, for example, now we have 30 million people living abroad. We are 1.3 billion. And there are 30 million people living in 195 countries. You imagine the traffic of litigation they bring in. Now, let's look at marriage. Everybody wants breakdown of marriage to come in, but irretrievable breakdown is not a ground for divorce. So you go to America, England, Canada, and divorce. What is the fate? You bring in a foreign divorce decree, it's no good in India. Why? Because it is not according to Indian law. And irretrievable breakdown is not a ground. So why don't we change the law? Let's make irretrievable breakdown as an optional ground for divorce. when a party is placed abroad. So let's make it an industrial ground. We have the fault theory, we have mutual consent. Let's make breakdown an industrial ground. Not for everybody, but for people who can use it. Let's cut down on litigation. Let's start building healthy families. Let's start having normal relationships. So this is a thought process which will emerge with burdening litigation. Now the Supreme Court is flooded with transfer petitions. A man files one petition here in one jurisdiction, wife files another petition in another jurisdiction. Now, when the transfer is from state to state, transfer petitions are filed in Supreme Court. So Supreme Court is saying we are burdened. There is one judge dealing with, let's say, 25 to 30 transfer petitions every day. So the court is saying, what do we do? So we actually need to look at a law again. We need to do our homework and we need to revise the law. So child custody is a big thing. There are conscious judges now looking at child custody. Otherwise, family law is a poor country cousin. You see, where is law amended? Law is amended where law brings money. Arbitration law, every day there is an amendment. Why? Because it's economically fertile. Family law doesn't bring in any money. Family law, no votes. So let us leave family law as a sleeping dog. So there is no change in family law. So this is the sad story. And we have no trained family law bar. We don't have a dedicated family law judiciary. Now look at Australia. Australia has a Chief Justice of the Family Court of Australia. So there are family courts all over Australia and the judges are separate and there is a Chief Justice. So you have 2,000 family law lawyers just looking at family law. In England, we have in the High Court a family division. So there is a segregated bar, there is a segregated judiciary looking at family law. In our country, family law is all mixed up in law, and a practitioner in law is a general practitioner. He will do criminal law, family law, property law, everything law. So this leads nowhere. So you must have at a lower level. Now, among the younger lot with 5-year law degrees, things are changing now. So maybe with passage of time, we may be able to evolve something concrete and we may have a better structure. Next question, please.
Next question, please, anyone?
I think your students are tired, sir.
Yeah, they must be, because it's a class that they don't attend at this point of time.
Anyway,
yeah, they probably don't have the energy that you have at this age.
Now, you see, you have to stretch yourself. I am 61 years of age. I've just undergone a knee and replacement and a spine surgery. But you see, work is something which has to go on. It doesn't stop. I have got 9 books. 2 years produces a book. So work and academics is something I like. I teach in academies. I teach in the Bal Judicial Academy. So work kicks you. Work energizes you. Work is a stimulant. So it depends on how you look at it.
So if there are no further questions from the students, then I guess.
Yes, sir. If anybody still has, we
okay,
can still.
Sir, yeah, we can still have sir respond to your questions. Anyways, if you have any other doubts, you can type a mail to me. I can redirect it to sir. So if he is free at any point of time, he can respond to those queries. Okay. Thank you so much, everyone, for joining. Thank you, sir, for this session. We hope that we had a we couldn't announce the lecture in advance, and probably that's one thing that the students may have been wanting. But next time when we host you, we wish to have a proper session, a better session, better planned session.
Maybe I'd like to come back to symbiosis, because I've lectured on the same live-in relationships where we had a overflowing hall. So I think live is better.
Yeah, sir. Yeah, we are opening up gradually, so that will be a possibility in a few months. Thank you so much, sir, for this session.
So nice of you.
Wish you a good night. Please take care.
Thank you very much. Good night. Bye.
Thank you. Thank you.
Bye.
Okay, then students, you can leave